Good evening. I'm Dr. Neeraj Nagpal. I'm Managing Trustee, Medico's Legal Action Group. And the reason I'm talking today is the dithering of the central government in forming a central act to prevent violence against healthcare professionals and healthcare institutions. Why is a central act needed? This is the question which is going around and which is being asked by the central government. The argument given to us against passing a central act is that 26 states have already passed Prevention of Violence Act against healthcare persons. These acts, however, have different versions or different sections, and they are not uniform. This results in doctors in many states and UTs being deprived of even the flimsy protection that is supposedly provided by these state laws. Under RTI, when we asked for a number of convictions under these laws from state of Haryana and Punjab, the answer given to me in 2017 was none. And this is despite the fact that the acts had been notified in 2008 and 2009. The second problem we face is the police personnel knows only the central laws, IPC, BNS, etc. Every time a complaint had to be made, a copy of individual state act had to be annexed with the complaint because the SHO would be unaware of the state laws. At some times, even the State Advocate General's office have asked me to supply a copy of the particular state law to them because they are not having a copy of that. So this is the level where state laws are not aware even to the people who are responsible for enforcing. Then I'm also told that you already have Indian Penal Code, you now have BNS. So what is the need for a special act to be made by the central government to prevent violence against doctors? The problem is we already had sections in Indian Penal Code and now in BNS against rape and acid attack victims to prevent them or to take action against the perpetrators of rape and acid attacks. Still, we went ahead and made a Criminal Law Amendment Act in 2013. This was after the Nirbhaya rape case. And the reason was because it was found that sections of Indian Penal Code were not found to be sufficient to tackle a particular type of crime which was prevalent. Similarly, we had the POSCO Act. Again, IPC sections can be used to prosecute people who perpetrate sexual offenses against children. But a special act was found to be necessary to curb these. And a special act was made. Similarly, PCPNDT Act, TOHA, Transplantation of Human Organs Act, Dowry Prevention Act, and many more central acts have been made despite the problem being tackled to some extent in Indian Penal Code, but because they were found to be insufficient to tackle the problem, so special acts had to be made, and these were made by the central government, even though these were related to law and order or healthcare. This argument that health and law are both state subjects, hence a central law cannot be made, is already countered by the number of central laws, special laws, which have been made despite law and order also being a state subject. So, and the problem is a state government, if has a state law for prevention of violence, and for one or the other political reason, refuses to implement, refuses to take action for political reasons, because the perpetrators may be politically linked or may be high rank holding people. If there is a central act in place, the central government will be in a better position to enforce a central law. How will the central government enforce a state law? Can the central government go and enforce the Prevention of Violence Act of West Bengal? It is the state government which has to do it. But if there is a central law, it is the central government's responsibility to enforce law and order under a central. So in these kind of situations where state governments, for political reasons, are not acting, it is better to have a central law so that overall supervision or interference can be run. The argument given by the Home Ministry when the prevention of central prevention of violence act was introduced in the parliament in 2019 was that other professions will also start asking for a special act. Now, our point here is that medical profession is sui generis. This is something I picked up from the legal terminology. And this means the medical profession is different from other professions because they provide their services to fulfill a fundamental right of the people. Ultimately, proper healthcare is a fundamental right of the citizen. And it is a right which is against the state government. Number of Supreme Court judgments are there which advocate that right to healthcare is a fundamental right under Article 21 of Indian Constitution. And it is also well accepted that it is a right against the state. But now, since doctors who provide healthcare to the public, whether in government or private sector, do so in place of the government. It is the government which is supposed to provide healthcare. And because government is not sufficiently providing healthcare, that is why private sector has come in. If government was taking adequate steps to provide healthcare to all the citizens, what was the need of private hospitals? There was no need. So to say that medical profession, if is asking for a central law to prevent violence, other professions will also start asking, does not make sense because no other profession provides services which are basically the fundamental right of the citizen. This is something which has to be understood. Any work I do to provide healthcare to my patient, and healthcare to my patient is his fundamental right. And whether I'm in private sector or government sector, if I am fulfilling that right, fundamental right of the patient, I am doing something which was the duty of the government to do. It was not my duty to do in the first place. It was the duty of the government to do. And if the government is not doing it, that is why we are fulfilling it. And these services cannot be compared with services of architects and lawyers and reporters and so on and so forth, chartered accountants. Then you also have to realize that violence against doctors differs from routine violence and crime because it harms innocent people. In a large emergency ward, when violence occurs, the innocent bystanders or other patients, there are 100 patients lying over there, one patient's relatives start fighting with the doctors. What happens? Everybody's attention is now focused here. This happened in PGI recently. And in the emergency, once violence broke out, all the doctors, nurses, their attention was diverted to this incident. And the other 99 patients who were there in the emergency were deprived of proper health care. Some of them were critical, and actually one patient actually died. So who becomes responsible for death of someone because somebody else decides to assault a doctor? This is something which does not happen in any other profession. When a doctor is assaulted, Either the staff will be, their attention will be diverted here, or the staff will be running helter-skelter to save themselves effectively, or even if the incident is transiently, the incident happens and things have been brought under control, the doctor is in no frame of mind by that time to be able to provide proper health care to his other patients. So any healthcare which he is continuing to provide is probably substandard. And anyone has a right to proper healthcare. No one deserves substandard healthcare. And this substandard healthcare the doctor is providing is because he has been assaulted recently and he is still not in the proper frame of mind. Another problem you have to realize is when doctors are working in rural areas, in difficult areas, they are facing a lot of problems because of poor law and order situation. There are local dons who want things to be done their way. There are quacks who have ruled the roost for many decades. And now suddenly scientific modern medicine comes in, it threatens their livelihood. There are myths and misconceptions in the public. Sometimes even lynch mobs in these areas because of the poor law and order situation. These have to be faced by doctors. So any violence there prevents 100 other doctors from going to work in rural areas or difficult areas. If you remember recently, there was a doctor in a tea garden and he was lynched to death because he was the only doctor to serve the community and he was on call 24 hours a day, 7 days a week. So for whatever reason, but he was late in attending to one emergency and the patient died and he was lynched to death. Tell me how many doctors would like to go and work in his place where he was working. If I have to look at only this incident of violence of R.G. Kar Medical College, will it not deter thousands of bright young girls from joining the profession? These are all reasons which distinguish medical profession from any other profession, which indicate that medical profession has to be treated as something different, as what the legal terminology says, sui generis, meaning to say that you cannot compare the medical profession with other professions. And making special laws, I have already argued that special laws are needed. The reasons also I have given why they are needed, not only a question of central law, the question of special law to be made over and above the Bharatiya Nyaya Samhita, so that this particular problem can be tackled and tackled well. Thank you so very much. I hope the message I'm trying to convey reaches those